Today we present the facts behind Imran Khan's Toshakhana gift scandal case. What is the background of this criminal case? Is the case really valid, just created to disqualify Imran Khan? What is Imran Khan's legal team standing? Why judicial system is questionable? Let's get started.
Imran Khan has been arrested at his home to serve a 3-year sentence for selling gifts he received as the country's leader.
Bismillahirrahmanirrahim.
By the time you hear this statement, they will have arrested me. I have only one appeal. Don't sit silently at home.
Let's first discuss what is Toshakhana. Toshakhana is a Persian word that means treasure house. In Pakistan, it refers to a government department that is responsible for storing gifts that are received by government officials. The Toshakhana was established in 1974 and it is currently under the administrative control of the Cabinet Division. A protocol officer is responsible to receive the gift and gets involved in appraisal and handling the president's transaction of acquiring the gift. Toshakhana gifts come from foreign dignitaries, such as head of state, ministers, and other high-ranking officials. These gifts are typically given as a token of goodwill or appreciation. Gifts can be anything from jewelry and artwork, carpets and antiques, gun, and yes, watches. Gifts that are received by the government officials are supposed to be deposited in the Toshakhana within 30 days of the officials receiving it. If an official wants to keep a gift, they're required to pay a certain percentage of the gift's value to the Toshakhana. The amount of the payment is determined by the Toshakhana Evaluation Committee. During the tenure of ex-Prime Minister Nawaz Sharif and President Mr. Zardari, the percentage to own a gift is 20%. Imran Khan paid 25% to purchase the gift, and later Imran Khan increased the law to 50%. Morally, Imran Khan should have increased the percentage to 50% before buying any gift, but legally he was allowed to pay 25% or 20% to buy the gift. Let's discuss the origin of Imran Khan's Toshakhana case. Imran Khan becomes the Prime Minister on August 18, 2018. The Saudi Crown Prince, Mohammed bin Salman bin Saud, visits Pakistan on February 17, 2019 and gives a costly Graf watch some other items to Imran Khan. These gifts were taken by military secretary, brigadier, and now promoted Major General, Mr. Wasim Chima. Now I will first explain the facts, strictly relevant to the legal part of the Toshakhana case, and we'll leave the drama for later. Toshakhana case against Imran Khan is filed on August 5, 2022 by members of the Pakistan Democratic Movement called PDM. PDM is a combined group of different parties like the Pakistan People Party, Pakistan Muslim League Nawaz Group, and MQM, BOP, and some other small parties. Imran Khan's popularity and terror was so huge that the political parties who were against each other decided to combine and create PDM. National Assembly Speaker Raja Pervez Ashraf sent a reference under Article 62(1)(f) the Election Commission for the disqualification of Imran Khan pertaining to the Toshakhana case in early August 2022. This is the same article under which Nawaz Sharif was disqualified for life. Let's discuss the basis for sending the reference to Election Commission. Imran Khan's children are born in United Kingdom and live there. Imran Khan created the party PTI and wanted the leadership to grow within the party. Pakistan's People Party and PMLN is a family dynasty and transfer their power to children. An incompetent party worker will never be able to become a future party leader. Imran Khan is a leader who has donated his property after his death to Toshakhana. Can Nawaz Sharif and Zardari do that? Never. Imran Khan was not earning any money from his cricket profession and decided to sell his watch. Imran Khan claims that when he was a prime minister, he did not use his own government's resources to construct a broken road, but used some of the money to build a road in front of his house. Nawaz Sharif used government resources to build roads and highways which leads to his palace in Raivan. During his presidency, he did not even build one hospital where he himself would like to get treated. Nawaz Sharif likes to get his treatment in the United Kingdom and will take a flight every time he feels sick. Imran Khan decided to sell his Toshakhana watch, and according to Imran Khan's version, he asked military secretary to sell the watch to a watch dealer in Islamabad, as he is a president and will not personally be walking into a watch store. The watch was appraised at 10 million rupees. 2 million was deposited in the Toshakhana account to acquire the watch. Election Commission complaint number 1 is that Imran Khan received the funds for the watch. Imran Khan's accountants filed 2020 to 2021 tax returns where the Toshakhana gifts are mentioned in the column of statements of assets and liabilities as precious items. In the Form B, Statement of Assets and Liability form, the cost of these total assets were duly and correctly mentioned in the relevant column. However, they were noted collectively as precious items and not named as gift from Toshakhana, which means that the total amount Imran Khan received from the sale of the gifts were noted correctly. The Election Commission's objection is that the gifts from the Toshakhana is not mentioned separately and noted collectively under precious items. Imran Khan's legal team's argument to the first complaint is that Imran Khan's accountants relied upon his tax return statements in support and as proof of the declaration made by him in Form B pertaining to each of the year 2018 to 2021 tax returns. The fact that the learned trial judge has totally ignored, which establishes the bias of the trial judge. Also, Imran Khan's team argued that the statement of assets and liabilities had been filled by his accountants and asked to bring his accountants as defense witnesses. However, the trial judge has refused to allow the appellant to produce his tax consultant as defense witnesses, on the grounds that the said witnesses were irrelevant, because the judge stated in Imran Khan's reply to question number 30 put to him by the court, the appellant has stated that he has not relied upon tax return wealth statement. However, in reality, Imran Khan's response to question number 30 states, I had relied upon my tax return wealth statement in support and as proof of veracity of the declaration made by me in the Form B pertaining to each of the aforesaid financial years. Imran Khan's team argued that the judge failed to review Imran Khan's answer to question number 3, and as Imran Khan stated, he relied on his tax return and exactly the reason why his accountants and tax consultants were mentioned as key defense witnesses to explain why the Form B is worded as precious items and why Toshakhana gifts are a part of precious items. Also, Imran Khan provided detailed explanation to the amount received from sale of the watch. The court asked why the full amount received from the watch sale was not deposited in the bank. Imran Khan argued that he has the right to keep some cash, and the amount kept as cash is noted in his tax returns. Therefore, he did not hide anything. As per Election Commission's complaint number 2, Imran Khan was required to disclose all assets purchased, acquired, sold, or otherwise disposed of him in the relevant year, but fails to do so. This is Election Commission's complaint. Election Commission is referring to some other Toshakhana gift Imran Khan received and which were not included in Form B. Imran Khan's legal team claims that he is only required to disclose the position of his assets as it existed on the specific cut-off date of the relevant year. At the timing of filing the tax returns, he did not have any gifts and gave all the gifts to somebody else or family members or relatives and did not receive any money in exchange for that. Therefore, when the time of tax filing arrived, he did not have those gifts and therefore he is not required to declare. According to Form B, Serial 2J, it reads in their entirety. It is evident that not all assets transferred to any person during the financial year are to be declared by a member of the National Assembly or Senate. Rather, only those assets are to be declared by him which has been transferred either without adequate consideration, which means by receiving money, or revocable transfer, which means transferring an asset property to a beneficiary or someone where your rights of recovery are revoked. This means he was not required to declare all assets, but only those assets which he sold with consideration, which means the assets which he sold and received with money, which never happened, and therefore he was not required to declare. The government witness stated during the trial, the parliamentarian will have to declare every type of assets which he has transferred or received during the financial year. At this stage, Imran Khan's defense team drawn the attention to the section referred to as Serial 2J in the Form B. The witness read the statement, and after reading the section, the witness agreed that as per Serial 2J in Form B, the only assets required to be declared by a parliamentarian during a financial year are which he sold with adequate consideration or by revocable transfer. The judge has ignored the entire set of evidence on the subject relating to the actual case facts and passed the judgment. Also, on the technical grounds, the Election Commission of Pakistan should have sent the case first to a magistrate and not to a trial session judge. As noted in Section 193 of the CRPC, Section 193 imposes an embargo upon a court of session to take cognizance of any offense unless sent by a magistrate duly empowered. Court is barred from taking cognizance of the case as a court of original jurisdiction unless the case is sent to it by a magistrate. Now I wanted to explain the timeline of this case in many facts, and the reason Imran Khan found the session judge Dilawar to be biased and against him. Election Commission of Pakistan on October 21, 2022 initiated the inquiry, announces a final verdict. An Election Commission of Pakistan disqualifies Imran Khan for not declaring the source, but not under the Article 63(1)(f), which the PDM government was hoping, but under the Article 63(1)(p), which disqualifies Imran Khan for 5 years. Imran Khan was disqualified for the dishonest behavior, fabricated information, and inaccurate declaration in the reference under the Article 63(1)(p). Basically, Election Commission of Pakistan did not have the power to disqualify Imran Khan for life under Section 63(1)(f). Whenever Election Commission of Pakistan disqualified someone, they have to make a decision and forward the decision to the court to proceed with criminal trial. On November 22, 2022, the Election Commission of Pakistan sent the Toshakhana reference to the trial court initiating the criminal proceeding against PTI chief Imran Khan under the section 137, 170, and 167 of the Election Commission Act of 2017. On January 5, 2023, a lawyer approaches the Islamabad High Court and requested full release of Toshakhana records since 1947. As Imran Khan's Toshakhana issue was in highlight, everyone wanted to know the gift received by all the prior politicians. Lahore High Court gives the order to release the gift details since 1947. On February 23, 2023, government tells the court that the details under 2002 are available as they are declassified, but the details from 1947 are not declassified and will not be able to release. Wonder why? I will attach the link in the description section for you to access the complete Toshakhana gift details since 2002. On March 13, 2023, Lahore High Court orders release of full Toshakhana records since 1947, which is still pending. On April 11, 2023, Imran Khan faces hurt. The district judge presiding the Imran Khan's Toshakhana case is Dilawar. Recently, Imran Khan's lawyers argued that the judge is not biased and carries negative views about Imran Khan. Those views are posted on his Facebook page and requested the case to be transferred.
अगर हाई कोर्ट ने ट्रांसफर दरखास्त कर दी तो नए जज साहब सुनेंगे, और अगर हाई कोर्ट ने ये दरखास्त हमारी खारिज कर दी कि ये जज साहब सुने तो हम फिर उसको चैलेंज करेंगे। लेकिन हमें ये खतरा है कि जज साहब जो है कानून के मुताबिक नहीं चल रहे, क्योंकि कानून पढ़ के दिखाया जा रहा है, कानून पढ़ के उन्हें बताया जा रहा है कि 526 के तहत आप जो है जब पेंडिंग आपके खिलाफ दरखास्त हाईकोर्ट के अंदर होगी तो आप दरखास्त जो है वो उस केस के ऊपर फैसला नहीं दे सकते। लेकिन जज साहब वो पहलू सारे जो हैं वो इग्नोर करते हैं और प्रोसीडिंग चलाई जा रहे हैं और इस केस के अंदर फैसला देने के लिए तैयार बैठे हैं।
Imran Khan's legal team argues that the Toshakhana case was purposely assigned to this judge due to his negative views about Imran Khan. Also, a complaint is pending in High Court against the judge under Section 526, which states that the party will not be forced to undergo a trial by a judge or a magistrate, whom he reasonably regards as being prejudiced against him. The legal team informed the judge to transfer the case, but he decided to continue proceedings. The legal team filed a complaint in the Islamabad High Court, and the court requested FIA to investigate the Facebook post to make sure if it's real or legitimate or not. The FIA is under Interior Minister Rana Sanaullah, who is anti-Imran Khan.
और अगर ये सड़कों पे आया तो इसका पहले इलाज इसका करेंगे, उसके बाद फिर इलेक्शन करवाएंगे। तुम धौंस दोगे तो फिर हो सकता है कि तुम फिर अगले साल मई में भी यही मुतालबा कर रहे हो।
FIA responded that the Facebook post link to the judge cannot be confirmed, as the page do not exist anymore, and therefore link cannot be further investigated.
साथ साथ ये बताता जाऊं कि ये जो जज हैं हमारे दिलावर साहब, इनकी फेसबुक आईडी के हवाले से FIA ने आज रिपोर्ट दी है। FIA ने ये कहा है रिपोर्ट के अंदर कि हमने जो इनकी आईडी है वो सर्च किया है, लेकिन वहां पर हमें कोई तस्वीरें, कोई मवाद नहीं मिला। तो पहली बात, क्या जज साहब ने जो आईडी है उसके बारे में कोई कंप्लेंट FIA को भेजी है कि ये मेरी आईडी थी और मेरी आईडी जो है वो ब्लॉक हो गई है या उससे तस्वीरें डिलीट कर दी गई हैं? 2014 से ये पोस्टें इनकी आईडी के ऊपर लगी हुई थी और आज तक वो आईडी ब्लॉक नहीं की गई, आज तक वो आईडी के ऊपर तस्वीरें जो हैं वो गायब नहीं की गई। तो अचानक से जब मीडिया के ऊपर ये आवाज बुलंद होती है कि जय साहब के जो आईडी है वो शो कर रही है कि वो खान साहब के खिलाफ है, तो उसके बाद जो है वो आईडी फौरन ब्लॉक हो जाती है, वो आईडी से सारी तस्वीरें गायब हो जाती हैं।
Imran Khan's legal team argued that the Facebook keeps record of the deleted posts for 60 days. If the FIA or the government will email Facebook, they will provide the details, but no one requested information from Facebook. The plea to transfer the case was pending in High Court due to lack of progress. Imran Khan's legal team approached the Supreme Court to request halting of the trial court proceeding against Imran Khan's Toshakhana case. The Supreme Court rejected the plea and referred them to wait for the High Court's directives. However, they did give remarks on the case, advising that when a transfer application is pending in the High Court under Section 526, subsection 8, trial court cannot give a final decision or an order. The Section 5268 states, after petitioner makes an application under Section 526, CRPC 8, the trial court, the proceeding must be stayed. Where proceedings are not stayed, proceedings are null and void for want or competence and cannot be cured under Section 537. On August 2nd, Imran Khan's legal team went again to same Judge Dilawar as he refused to halt the case proceedings and insisting on giving the verdict. Imran Khan's team provided the list of witnesses to bring in favor of Imran Khan's case and also requested to get some time before the evidence can be collected and submitted. These witnesses include the accountants who completed Imran Khan's declaration form. Imran Khan argued that the accountants who completed the forms should provide justification as to why Election Commission forms did not mention the word Toshakhana under the asset section. The judge asked the witnesses to be presented that afternoon, but the legal team argued that witnesses cannot come the same day. Some time is required. Imran Khan's legal team again approached Islamabad High Court and argued that a lower court should allow us ample time to present our witnesses, which is important to justify Imran Khan's case version. As the case was being heard at the High Court, the lower court refrained from giving the verdict. On 3rd of August, High Court delayed the decision regarding Imran Khan's request for presenting witnesses at the lower session trial court, but strangely directed the session court to proceed and give the final verdict on the Imran Khan case on August 4th.
देखिए फैसला है क्या, ये समझना बहुत जरूरी है कि जो गवाह पेश करने की सजा है इमरान खान साहब की, उस पर जो गौर है वो अगले हफ्ते होगा। इलेक्शन कमीशन को नोटिस जारी किया, लेकिन उसी दिन 3 अगस्त को इस्लामाबाद हाई कोर्ट ने ट्रायल कोर्ट को यह कहा कि आप फैसला कर दीजिए। यानी 4 अगस्त को जो डेट ट्रायल कोर्ट में थी नीचे एडिशनल डिस्ट्रिक्ट सेशन जज साहब के पास, उन्हें कहा गया कि आप फैसला कर दीजिए इसका। ये अजीबो गरीब सूरत हाल है कि एक तरफ हाई कोर्ट अभी ये फैसला करने बैठा है कि गवाहान की इजाजत देनी है मुलजिम को या नहीं देनी, और ये भी एक अनोखी सूरत हाल है कि मुलजिम को गवाह पेश करने की इजाजत नहीं दी जा रही। और इस्लामाबाद हाई कोर्ट कहते हैं इस मामले को भी हम देखेंगे अगले हफ्ते, और साथ ही ट्रायल कोर्ट को कहते हैं कि तुम फैसला कर दो।
On August 5th, the police was already at Imran Khan's house, like they knew about the details of the verdict in advance. Barrister Salman Akram Raja, who is a very senior lawyer in Pakistan and whose opinion is very neutral, has this to say.
और ये बिल्कुल वाज़ेह है बात कि ये तमाम मंसूबा पहले से तैयार था, हर इदारे को पता था कि कब कितने बजे फैसला आना है, क्या वो फैसला होगा और उस पर क्या करना है।
The additional session judge announced his decision giving the conviction verdict, and Imran Khan was arrested from his house in Zaman Park, Lahore. Imran Khan is in Attak jail, which has no jail class, and according to the report, he is in a 6x9 foot jail, kept in bad condition. As Imran Khan knew that he will be arrested, he had a video already recorded and was released after his arrest.
जब तक ये पैगाम आप तक पहुंचेगा, मुझे ये अरेस्ट कर चुके होंगे और मैं जेल में होऊंगा, तो मेरी आपसे सिर्फ एक ही रिक्वेस्ट है, अपील है कि आपने घरों में चुप करके नहीं बैठना। मैं ये जो जद्दोजहद कर रहा हूँ, ये अपनी ज़ात के लिए नहीं कर रहा, ये अपनी कौम के लिए कर रहा हूँ, आपके लिए कर रहा हूँ, आपके बच्चों के मुस्तकबिल के लिए कर रहा हूँ। पुरअमन एहतजाज आपने करते रहना है जब तक कि आपको आपका हक नहीं मिलता, और वो सबसे बड़ा फंडामेंटल राइट है वोट के ज़रिए अपनी हुकूमत मुंतखब करना, ना तो किसी और कोई कब्ज़ा ग्रुप इस मुल्क के ऊपर कब्ज़ा करके बैठ जाए जो आज कब्ज़ा करके बैठा हुआ। शुक्रिया।
Because Imran Khan's disqualification is less than 5 years, this is a bailable offense. But on August 8th, an appeal was filed at High Court and Imran Khan's bail was rejected. Now the appeal will be filed in Supreme Court. However, there are more than 150 bogus cases filed against Imran Khan. If the Supreme Court will grant a bail to Imran Khan, the establishment will arrest him again in a new case. So unfortunately, might is right. If he gets another bail, he will be arrested in another case. If he gets another bail, he will be arrested in bogus cases. There's a lot of propaganda about Imran Khan's watch being sold in Dubai and not in Islamabad. But none of these complaints were mentioned in the case because there is no evidence. The watch was sold in Islamabad and then the person who sold it left the shop for a few days. The establishment was haunting the person and was forcing him to give a statement against Imran Khan. The shopkeeper gave a statement that his letterhead and the stamp was forged and was misused, and the invoice for the sale of the watch do not belong to him. The funny thing is, if he was telling the truth, why he had to sell his business and disappear? It appears the establishment threatened him. The watch was sold to somebody in Dubai who has it, but there is no evidence to prove, and the buyer did not say that it was directly Imran Khan selling the watch. Let's hope justice prevails and Pakistan can move towards law and order. Thank you very much for taking the time to watch this video. It is really important that you do please subscribe my channel to support so I can produce more content for you. Thank you. Take care.